error for some reason or whatever, we will take those phone calls. We will revisit any property that we feel that needs to be reviewed. Then by August 17th, anyone that wants to file a formal appeal before legalization, those begin in late August or early September. So as we mail these 38,000 notices, there's plenty of opportunity for the taxpayer to contact us, to ask us any questions they have about anything about their property value, and we'll work with them. If there's any discrepancy there, things like that, we'll put that in the time that we visit those. And that's kind of where we're at right now.
So is everybody clear on our procedures, where we are? It's taken us 5 years to get to this point. Thank you very much for the report.
All right, thank you.
On the criminal justice, I don't really have any specific report. We continue to produce the justice report in a new format. I think it's easier and clearer to look at it. You've had a chance to look at that. The business that we have tonight, I'm not going to point anything out. We will be working to rejuvenate our justice system analysis that the COVID-19 issue has taken the wind out of the sails, as we say. So we will be refocusing on that in the Criminal Justice Coordinating Committee and all related activities. So with that, I think there are a couple of memos in the packet related to these ordinances. I've got a memo in there on page 16. The prosecuting attorney's got a memo on page 17. I trust that you've read those. With that, I would recognize our first speaker, KrissAnne Hall. So, Ms. Hall, if you want to come forward.
Thank you, sir, for this opportunity. I want to thank the Arkansas Liberty Coalition for inviting me to come and address you. Since I am new to you, maybe by face, I'll give you a little bit of introduction. I am a constitutional attorney. I was a prosecutor for nearly a decade. I practiced First Amendment law for several years. I was also assistant counsel to the Department of Elder Affairs in Florida, where I wrote director's opinions and wrote statutes and such. And for the last 11 years, I've been teaching the Constitution. I've been a legal consultant on major media locations, and I've written 6 books on the Constitution of the United States and state constitutions. I have also taught the legislators of 10 states in session based on the U.S. Constitution and state constitutions, and I teach law enforcement, sheriffs, deputies, police officers all across the country as well. I've been brought in to speak to several issues, and I do apologize. I have written down my statement, and I don't have, Mr. Chairman, the memos that you referred to. The only memorandum that I have is from Rainwater, Holt and Sexton injury lawyers, and to that is what I've been asked to address concerns. Now, the people have asked me and are asking you, the county, to vote in favor of a Bill of Rights Ordinance that would act as a constant reminder and a visible barrier to the securing of every right, not just the Second Amendment. We're talking due process, we're talking about property rights, we're talking about separation of powers, we're talking about every right that is enshrined, not just simply in the Constitution of the United States, but in the Arkansas Constitution as well. And the people of this county are acting out of concern, not only for their own rights, but the rights of future generations. And one speaker came before you and said, I don't think that constitutional law is an issue for you. Well, I beg to differ. Each and every one of you took an oath of office, and that oath specifically demands a dedication to the Constitution of the United States and the Constitution of the state of Arkansas. And so that's why this is important. But oaths may be clearly written, but over time there's a temptation for any person in office to lose sight of that promise and become prey to the line of thinking that dilutes the significance to their posterity. And I submit to you that a legal and historical review of the challenges to this ordinance will leave this body with the confidence to move forward with the will of the people and take up this ordinance for consideration. Now, according to the only memorandum that I have, Mr. Rainwater begins his challenge of the ordinance by telling this body that there's, quote, no need for such an ordinance. Now, no need is a statement of opinion. It doesn't equate to law nor prohibition of any action. It simply means that the action is not necessary based upon some other pre-existing situation. The fact that Mr. Rainwater feels that there's no need for this proposed ordinance can hardly be viewed as grounds for the county to refuse consideration or deny passage of such ordinance. In his plea, Mr. Rainwater then asserts that this ordinance cannot be accepted because it assumes the county is something it's not. He claims the county is not a sovereign entity. Mr. Rainwater's argument that the state is sovereign, not counties, is not supported by the Arkansas Constitution, Arkansas Code, nor is it supported by the Constitution of the United States or Supreme Court precedent.